Topic is mutation. Always in usual language, the mutation means affecting the name in the revenue records relating to agriculture land, called as mutation. Just you note down what is meant by mutation. Mutation is nothing but affecting the name of person who is having acquired the right pertaining to the agriculture land. His name shall be incorporated in revenue records. That is called as mutation. Another word is record of rights. Our right should be incorporated in revenue records. What right we are having, all these things shall be mentioned in RTC. RTC means record of right, that is maintained in the revenue office. So therefore, this mutation, how to be effected, under what circumstances it can be effected. So therefore, it is practice on the revenue side. Those who are practicing in revenue courts, that is Tahsildar, Deputy Tahsildar, then Assistant Commissioner, Subdivision, then the Deputy Commissioner of the district. These are the authorities comes in the revenue affecting the mutation. They are the authorities. First start, that is village accountant. Village accountant who is residing near our village or in the circle of the village, who is maintaining the revenue records pertaining to the names of agriculturists who are acquire the title to the properties. Their names is incorporated in revenue records in respect of agriculture land, in respect of survey numbers of agriculture land. So that village accountant is managing all the affairs. Next, how they are managing. Revenue inspector is circle, one circle is available. Among the circle, 2 or 3 village accountants are there. They have to manage all the affairs of the circle, in particular circle area. That is Hobli. The Hobli, Utrali Hobli, likewise Begur Hobli. So in a Begur Hobli, so many revenue inspectors are there because this is big Hobli. According to the same Utrali, Kaglipura Hobli is there. Kaglipura is also one of the circle, revenue circle is available. Revenue inspector is the in charge of the circle. Village accountant, so many village accountants were also deputed under him. They are the authorities maintaining the revenue records in the village as well as in the circle, and they used to issue the certified copies of the RTC. RTC means records of right in respect of agriculture land. So now, main question will be arises. Who is going to be incorporate our name? Under what circumstances they have to incorporate our name in the revenue records? First of all, I want to say that Chapter 11 of Karnataka Land Revenue Act, note down, this consists of sections 127 to 136, Chapter 11. You must note down the Chapter 11 consists of 127 to 136 provisions, sections are available, and this is called as records of right, how to be managed. So therefore, you have to note down in Karnataka Land Revenue Act, Karnataka Land Reforms Act is entirely different from Karnataka Land Revenue Act. And Karnataka Land Grant Rules is another one. So likewise, Karnataka Land Revenue Act, there are provision, Chapter 11, Section 127 to 136 sections are deals with records of right. A person who is owner of the agriculture land, their names shall be incorporated in RTC. So that is called as, if name is found, mutation. So mutation means explaining mutation registered, MR number. Usually you have to come across wherever you are getting the RTC. MR number is found at column number 11, column number 10 and 11. And column number 9, the name of the person is available in RTC. These are the three columns denotes the names of person who is owner and how his name has been arrived or derived. Mutation register, that is MR number 1 bar 9293, 1 bar 2012, 2013. Likewise, mutation register maintained in the office of Tahsildar called as MR number, particular mutation register number, that is name of the person. Now, 127 deals with 127 of the Karnataka Land Revenue Act that deals with, kindly maybe look into, these are the particulars required. A record of right shall be prepared in a prescribed manner in respect of every village, and such record shall include following the particulars. So what is the RTC? First you note down, these are the particulars are available in the RTC. The names of person who are holders, occupants, owners, mortgagees, landlords, tenants of land, assignees of the rent or revenue thereof. All these persons' name is available. Those who are having acquired the title, holders, occupants, owners, mortgage, even the land going to be mortgaged to the Land Development Bank, their name is also appeared at column number 11 and 12, because whatever the rights extra is available, the RTC if you have opened, RTC if you have taken, 15 rupees charges is there, any survey number and extent of land, how much assessment of there, and what are the names of the persons who has acquired, and subsequently whether it has been mortgaged, all the particulars going to be given. That is called as RTC, that is persons. The nature and extent of respective interest of such person, including so many 3 or 4 persons are available. Their MR in survey number 29, it may be having 10 acres of land. Out of 10 acres, 5 persons are purchased. 5 persons' name shall be incorporated along with the extent. How much extent they are having in MR number so and so. 10 acres of land in survey number may be having, but one person is not having ownership of 10 acres, but some other person who are purchased because due to selling of the land, due to mortgage of the land, lease of the land. So likewise, if it is available, and their name shall be available along with the extent of land, the rent or revenue payable to the government. Now, whatever rent assessment payable to the government is also mentioned in column number 4 or 5. Such other particulars, it may be records, that is called as records of right under section 127. So particulars of a person, particulars of occupants, particular of mortgage, particular of leaseholder, and assessment of the property and extent. These are the particulars are available in RTC, that is called as under section 127, deals with such prescribed form is available in revenue records. Now, Main question arises, that is always while being advocate, while you are practicing in revenue side, you must know what is the section 128, because 128 deals with who are the persons entitled to incorporate their name in RTC. That is called as acquisition of right to be reported. Now, acquisition of right. I am having said it, I must inform to the revenue authority. Somebody is having by way of heirship, that is by way of succession. They should inform, father died, we are the legal heir, our name shall be incorporated. This is one sale deed, one succession, another gift, another mortgage. Likewise, whatever the registered document is available, their name shall be, they shall make an application before the jurisdiction Tahsildar. Now, Tahsildar is having two categories. Just note down because very, very important. Tahsildar having two categories. One is grade 1 Tahsildar, another one is grade 2 Tahsildar. This has been in the year 2011, there is a circular issued by the government stating that entrustment of the work to whom they have entrusted. Tahsildar grade 1 is having a right to incorporate, mutation maintain, inquiry should be conducted, whether fraudulent act done in respect of revenue entries, all these powers are grade 1 Tahsildar. Grade 2 Tahsildar, Sakala maintain, information regarding Sakala, cash certificate, and other miscellaneous work. He should not conduct the inquiry. In one case, come across before the Honorable Tribunal, Karnataka Administrative Honorable Tribunal. Bangalore North Taluk, what happened? Grade 2 Tahsildar was deputed for work as a Tahsildar. Then the same has been questioned by one of the grade 1 Tahsildar, whether the grade 2 Tahsildar has deputed for this. He is entitled to work as a Tahsildar grade 1. No. So therefore it is decided in before the Karnataka Administrative Tribunal, when grade 2 Tahsildar is not having jurisdiction to inquire into the matter, to incorporate the name of the revenue entries. Therefore, a grade 2 Tahsildar cannot be deputed. Likewise, the same thing is happened in the Bangalore South Taluk also. Myself, I have filed a case before the tribunal. I got the order against the grade 2 Tahsildar stating that he should not work as a grade 1 Tahsildar, for which I have filed, I got the order. So same thing, you must know what are the duties and functions of grade 1 and grade 2 Tahsildar. So you must know that grade 1 Tahsildar cadre inquiry, it is sustainable in law. If grade 2 Tahsildar rendered any inquiry relating to the mutation, relating to the title of the parties, any conduct or fraud has been took place while mutation, whatever the inquiry conducted by the grade 1 Tahsildar, same grade 2 Tahsildar he should not do. That is the right of the Tahsildar cadres. So you must aware grade 1, grade 2 Tahsildar, who are they and what are their nature of work. So therefore, section 128 is concerned. Just this is, I want to read first line. You see, 128 into bracket 1. Any person acquiring by succession. You see, father dies, children are coming before the court, before the Tahsildar making an application, my father died, along with application, death certificate shall be included, and also he shall mention about his genealogy tree, that is Vamshavraksha. Genealogy tree he shall incorporate, and both application shall be made, death certificate along with he seek succession, because we are acquiring title on the death of Karta of the family, kindly maybe our name shall be incorporate. That is, two documents are required while effecting the mutation, one death certificate, one Vanshuraksha, and one RTC of the father whose name is stands, who is a Karta of the family. These three documents, along with application, should be made before the Tahsildar of concerned taluk, and it will be inquired by the revenue inspector and village accountant. They are submitting the report. Yes, they are having cultivation and his name is appeared. Now, report they should send to the Tahsildar. So whatever application made by the successor, it can be effected. Next, inheritance, survivorship, inheritance. All these words, succession, survivorship, and inheritance. These are the word has been used. They have to make an application of the family members, those who are having survivorship certificate, those who are having survivors of the particular land, and inheritance, because the ancestral property inherited from the ancestral property, the persons of the family, they shall be incorporated. Why these two words, survivorship and inheritance, has been made? Because all other family members name wants to be incorporated, but tomorrow it is going to be dispute among them, so therefore always the usually called the persons, all of the persons before the Tahsildar, saying that give the no objection when the it is title is not going to be pass on them. So it is only name going to be incorporated in revenue record. Such being the case, one name you may be permit them incorporate one name of the family members. So therefore, survivorship, inheritance, succession, always when the complete Vanshuraksha, that is genealogy tree, along with the death certificate mentioned by all the three persons, it can be incorporated in the name of one person of the family and continued in his name. Next, partition. Registered partition shall be available. Pan parikat is not maintainable. That is always Arshan Kunkuma and partition we have made based on our acceptance. That is, it cannot be a partition. Registered partition shall be available. And purchase, that is sale deed, mortgage, gift among the family members, lease, or otherwise. Any right as holder, occupant, owner, mortgage, landlord, tenant of the land, assignee of the rent or revenue thereof shall report orally or in writing his acquisition of such right to be prescribed officer, village, within 3 months from the date of such acquisition. 3 months time has been provided. Now after death, after lease, after registered document getting by him, that all documents shall be maintained within 3 months. They should make an application before the concerned authorities, concerned officers in written report. Next, the proviso is there. What is the proviso? Why provided that where the person acquiring the right is a minor or otherwise disqualified, his guardian or other person having charge of his property shall make report such prescribed. Now, if the minor, on behalf of minor is also gift or anything made, then the such documents shall be represented before the authorities. He is a minor. Further, that any person acquiring right by virtue of registered document shall be exempted from obligation to report prescribed officer. Now what happened? In formerly, the sale deed going to be placed. Now, sale deed immediately on registration of sale deed shall be sent to the Tahsildar now every day. Wherever agricultural land purpose, if registered sale deed is available, that registered sale deed is also sending to the this one. Provided to any person reporting under this subsection, acquisition by him, right in partition in respect of land, shall annexed with report of sketch showing the metes and bounds and other prescribed particulars of such land and such person shall get the sketch prepared by the licensed surveyor. Now, what happened? 10 acres of land is there because these are the terms and conditions, because the provided means what are the necessary documents are required. Therefore, in this case, wherever the partition was took place, it shall be annexed the sketch to be prepared by the licensed surveyor. Now 10 acres of land is available. 2 acres of each has been uh, divided among them. That survey sketch should be, because for boundary purpose, for assessment purpose, that shall be made. So therefore, it must be partition deed wherever it available. The sketch shall be prepared. The sketch shall be given. Then they can ascertain how much extent he is having possession and how much he can made out to acquisition of right. So that is also provision. In these provision also provided, all these facts are given, but still there are explanation is also mentioned in this section. Include a mortgage without possession, but not include in the easement or charge not amounting to a mortgage, because some of the mortgage is going to be given without possession. These need not be required to incorporate their name, because mortgage property may be available, but without possession their name is a need not be mentioned. But one thing is there: when the titles are deposited, amounts are issued through PLD bank or to some other bank authorities, financial institution, their name shall be incorporated at column number 11, because itare hakkugalu, other rights of the parties in the particular land is concerned, that also can be incorporated. A person whose favor mortgage is discharged, extinguished, lease determined, and acquire the right within the meaning of this section. Even while redemption of mortgage also, it can be incorporated in the records. These are these point of section. Several other period, 3 months time. Tahsildar is the report authority. The revenue officer shall be called as by virtue of, and any dispute arises among them, these are the persons who are entitled, eligible to get the mutation. If any dispute arises, immediately Tahsildar can refer this matter, registration of disputed cases. So now, because we are being a lawyer, we are advocates, we must come across what are the dispute arose between for incorporating their name in the RTC. Now dispute starts. One of the family member going to make an application stating that no, his only name is not be required, and wrongly it has been mentioned my name shall be incorporated. Then immediately it has been referred for disputed cases. Disputed cases going to be referred either Nad Kacheri, where the deputy Tahsildar is working as a Tahsildar, he shall inquire into the matter. He shall inquire into the matter why the disputed cases to be inquired to him. He has to pass detailed order, and that order, based on that order, whether his application eligible for incorporate his name in RTC or not. So therefore, section 129 is concerned. You must know RRT proceeding, RRT dis, that is the word used in the number, while disputed question is available before the Deputy Tahsildar or Nad Kacheri Deputy Tahsildar, who is in charge of the inquiry, shall be conducted, and the Deputy Tahsildar shall submit the report whether he is eligible, his name to be incorporate or not, under what circumstances his name can be continued. So likewise, wherever one application if made relating to particular survey number, that shall be referred for inquiry purpose, or Enquiry shall be conducted by a grade 1 Tahsildar only. So therefore, be aware that RRT dispute always, because we are the advocate. Yes, sir, RRT dispute, what is meant by RRT dispute? You must say that one person going to dispute about the name available in the RRT under section 129, it shall be referred for the purpose of inquiry and decide there. And one thing you should aware that how to be decided whether the only purpose of name to be incorporated or not, but title should not be disputed. The Tahsildar revenue officer is not having jurisdiction to decide the title of the parties. That has been decided. Our courts. Kindly maybe look into this is one thing. Note down ILR 2002 Karnataka 2950 reported judgment to ILR 2002 Karnataka 2750 Narendra Singh versus Special Deputy Commissioner. I think you note down wherever the dispute between the parties, the revenue authority shall not, mandatory order, shall not decide the title of the parties. This is also decided by the court. And another decision also, 2001 into bracket 1, Karnataka Civil and Criminal Report, KCCR 488, Basappa Nagappa Makapur versus the Assistant Commissioner. In that case, decided by the Honorable High Court of Karnataka, they must approach the civil court. That observation in the order. If you want to confirm your right, since there is a disputed right is available between the parties, those cases shall be visit before the revenue court or civil court. So in earlier case, Narendra Singh case relating to the will means if the will is disputed by other parties, definitely always will is under the dispute. Under the will is concerned, it is very difficult to prove the title. So therefore, inquiry should not be conducted about the genuineness of the will. That is, in the Narendra Singh case versus Special Deputy Commissioner, it was decided. Now, next question you may ask me. Yes, sir, will is genuineness of the will. How can it is going to be proved? Where we should prove? Because will is always under the dispute. So therefore, rightly held by Honorable High Court of Karnataka must get probate. Probate proceeding shall be initiated. If there is a persons are disputed, then it is going to be converted as suit. And in the suit, declaration shall be made who is the owner of the property and whether the rightly will has been bequeathed the property by the person who is owner of the property in favor of entitlement of and right entitlement under the will. So therefore, in both cases is concerned, civil court is having jurisdiction to wherever the dispute arose between the parties. RRT dispute means it shall be referred to inquiry into the matter, and that order going to be questioned. Next I will come. Now, 129, register should be maintained relating to RRT, that is registration, mutation of registration. So one thing you should not think over that, sir, why the mutation is called in respect of agriculture land, why they should not called as khata, because khata extract tax pertaining to the site, converted site, only it is called as khata. It is called as khata certificate, it is called as khata extract, and tax paid receipt available in respect of site. But mutation is nothing but khata, giving all the particulars in a single form, that is RTC, record of right. That is RTC giving all the particulars: who is cultivating, what is the land, whether it is red mist land, whether they are cultivating, what type of growing the crops, all the particulars available in the RTC. So therefore, it is called as mutation, giving all the particulars of the land, how much extent, what is the assessment, and who are the owner, and how many persons are mortgaged or deposited the title, and other rights of the person, and who is having cultivating the land, this, and what are the crops they are raising, whether the farmhouse is available, whether borewell is available, whether irrigated land, all these particulars are available in RTC. So that is called as section 129, they shall be maintained. 129A, it is incorporated to issue the patta book pertaining to the land. Patta book contains owner, his mutation number, how much extent of land, and whose name it stands. That is the patta book. Always going to issue under section 129 capital A. 130 is obligation to furnish the report. 130, what it happened? Tahsildar should not be denied particulars about the, if you are going to ask RTI under Right to Information Act, if you ask, they should report to the authorities. So therefore, obligation to furnish the report, if any required made by the persons under section 132, it is obligation on the part of Tahsildar or the office of the Tahsildar. They have to give information to the public at large. And this is 131 is very, very important to assess the property, how much value, how much tax should be payable. That assessment column is at number 4 and 5, it is available. And in that assessment, they should mention showing that ane rupai ist ane, that is the tax. Assessment means tax column is also available in the particular land. And next is 132. It is very, very important. Very, very important 132. Because one case I have come across. 132, if you don't want to submit your particulars along with the application or in the suit, it can be rejected easily. Straight away they can reject. When you have not furnished all the particulars along with the application, straight away it can be rejected. Then 133, the whatever the entry is available, it is presumption only. It can be presumed that he is the owner, he is having right over the property. That shall be mentioned in the particulars. Next, certified copy shall be issued by the Tahsildar office. That is section 134. 135 is very, very important for you being an advocate. You should not file a suit pertaining to the what I have submitted before now. Whatever I have rendered, whatever I have given now, particulars relating to the mutation and all these things, you have no right to file a suit relating to the mutation. Sir, mutation shall be continued. Sir, mandatory injunction can be issued to the Tahsildar. No, suit is bar under the section 135 of Karnataka Land Revenue Act. Now, 136 is very important. 136, why it is important? I want to say there are 3 ingredients in this case. 136. It is the right of the advocate. It is right of the client. They want to file a case before the Assistant Commissioner against the order of the Tahsildar. Any order going to pass relating to the mutation, that shall be questioned before Assistant Commissioner of Subdivision. Now, Bangalore is having South Subdivision, North Subdivision, and Rural Subdivision at Devnalli, the Dodbalapura. So likewise, the assistant commissioners who are having subdivision, they have to deal with 3 or 4 tahsildar comes under their jurisdiction, and they have to uh, entertain the appeal, whatever order passed by the tahsildar, whatever order passed by the uh, deputy tahsildar, those orders shall be questioned before the appeal before the assistant commissioner. That is the section 132, 136. Appeal and revision. Appeal and revision means the provision chapter 5 shall not apply to any decision or order under the chapter. Any person affected by an order made under subsection 4 or entry certified copies under subsection 6 of 129 may within period of 60 days from the date of communication of the order. And so I told you, if you want to register your name, there is a 3 months time has been given. You should submit application. Now the limitation for filing of the appeal, any dispute order has been passed by the Tahsildar or Deputy Tahsildar, that shall be questioned within 60 days from the date of order before the Assistant Commissioner. That is, within 60 days, appeal of such officer may be prescribed state government on behalf of or his decision shall be final. Appeal, always appellate authority is having great vast jurisdiction. They can inquire, they can get the address argument, they can remand the order to the Tahsildar to conduct the inquiry. All the powers and functions available to the Assistant Commissioner. Because RA, regular the revenue appeal, that is under section 136(2). What type of appeal we are going to prepare? Names of the parties, and Tahsildar is the first party. Second party who is disputed and whose name is entered, even though his name cannot be incorporated in the RTC, therefore his name is included. So such person, such appeal shall be filed. Name of the under section 136(2), memorandum of appeal under section 136(2) of Karnataka Land Revenue Act. And this appeal is just like a plaint. Whatever the memorandum of appeal you are going to prepare, I am so and so, and I am owner of the property. My name is not incorporated by virtue of order, and all these things and grounds. Then relief. Set aside the order passed by the Tahsildar and direct the Tahsildar to incorporate our name. That is the appeal under section 136(2), that is called as RA number bar so and so. Likewise. So this practice is very useful for you because our agricultural status, our in and around of the Bangalore, so many mutation disputes are available, and you have to take advantage of easy practicing because such provisions are available for the advocate is concerned, and you can also file appeal before the Assistant Commissioner. Now, against Assistant Commissioner, what you have to do? Next question. 136 class 3, that is revision order. Limited power has been given to the Deputy Commissioner to set aside the order of Assistant Commissioner under the revision petition. So the both authorities having appeal and revision. The Assistant Commissioner is the above the rank of Tahsildar, and above the Assistant Commissioner, the Deputy Commissioner, memorandum of revision petition under RP number so and so. Memorandum of revision petition under section 136 class 3 of Karnataka Land Revenue Act, same type of petition, and whatever the grounds you want to mention in the grounds, same prayer also, same thing. These are the provision available under 136. Now, I think you understood this chapter 11. 127 to 136 sections are available relating to the mutation, appeal, revision. Now, against the order of Deputy Commissioner, where should I question? Then some irregularities definitely available in the order of the Deputy Commissioner. You have to question, you have to take advantage of under Article 226 and 227 of Constitution of India before Honorable High Court of Karnataka. So therefore, you have to take advantage of this irregular proceeding might have conducted by the Deputy Commissioner or Assistant Commissioner that is upheld the order. So therefore, both order can be set aside, and that advantage you have to take chance to file a writ petition before Honorable High Court of Karnataka against the order of Deputy Commissioner, and you have no right to question. You have no right to question until and unless exhaust your remedy available to the now directly you cannot move the matter against the order of the Assistant Commissioner before Honorable High Court of Karnataka. Until and unless exhaust the remedy available to you, you must go before the Honorable High Court. Now, all these things available. Several judgments are come over. Several judgments are I have come across. So therefore, whether the High Court is having jurisdiction to issue direction to effect the entries in the name particular person only. No. High Court is also not having jurisdiction to enter the name, because how the name is continued, that can be irregularities made by the authorities that can be assessed. But title is concerned shall go before civil court only. And any decree going to be passed, it is obligation on the part of the Tahsildar. In the declaratory decree, what it means, only between the parties, not Tahsildar as a party to the proceeding. Because once again, it is very difficult to serve the or bring them before the court. They are not necessary party, because rights between the lists between the parties, rights are under dispute between the parties, shall be decided civil court only on decision of declaration decree passed. That decree shall be entertained by the Tahsildar to effect the mutation. So this fact is available for you. I think you understood, first of all, what is meant by mutation and how it is the procedure laid down, and what are the appeals, who is having jurisdiction over that, and this is the judgments are passed. And one of the decision, 1981 KLJ 419, immediately on sale deed executed between the parties, that sale deed is sufficient to effect the mutation. They should not deny. That is also judgment N. Sivanna versus State of Karnataka. That is 1981 Karnataka Law Journal, page number 419. Based on the sale deed also, you can move the matter before the authorities. These are the several decisions are available. And even Sagudi Chit also, granted land. Sagudi Chit is nothing but sale deed to the grantees. On placing of the Sagudi Chit, they shall be effected. Grant order is available. Everything is available. The mutation automatically effected. So these are the relating to the mutation is concerned under Karnataka Land Revenue Act relating to agriculture land. Thank you.
Thank you, sir.
Welcome, sir. Is there any question?
Sir, there are some cases where agricultural lands are unauthorizedly converted to residential land. So how does Tahsildar deal with such cases where there is a mutation order?
That is under section 67 class 2, unauthorized occupant shall be removed from the agriculture land, sir. There are section, eviction provision is there. There are powers and function of the Tahsildar, you can read it. Because always it is confused for mutation. What is meant by kata, why the mutation, the word has been used, and what are the RRT dispute, why disputes are coming, and why the RA regular revenue appeals are filing, why the RP is filing. So that purpose only today I have given elaborate lecture on that.
Thank you, sir.
Welcome, sir. It is very useful for practice, sir. Easily available, because based on the document only, you see unnecessary dispute going to be raised by the person. The sale deed, even though sale deed available, they are going to dispute. So one thing I want to, another one example I am giving to you. I am having 5 acres of land, out of which 1 acre 20 guntas I have sold and put him into position. I went to foreign countries for some reason. Now, while coming to know, after lapse of 5 or 10 years, who has purchased the land, he has created a GPA on behalf of me and sold the property in favor of their father, his father. And immediately father's name is appeared in revenue record. I have shocked. I have questioned before the authorities. Without giving any authority, the GPA holder who got the registered sale deed, who has executed registered sale deed, I have not at all executed GPA. My name shall be restored. So likewise, the fraud which was played by the person, and that shall be going before the civil court. But meanwhile, you are having a right to continue your name, because no notice has been given while registering the name, because the GPA holder executed the sale deed in respect of remaining property out of 3.5 acres. So therefore you can also seek for, because there is a dispute, I have not received any notice because I have not executed sale deed. That is also RRT dispute, comes within the purview of Land Revenue Act. Yes, anything else you want to clarify?
No, sir.
Thank you.
Thank you so much, sir. This is a very important topic, and everyone should aware of that.
Yes, madam. You have to give education to the public at large. Then only they can understand. Otherwise, it is very difficult, madam. Because until and unless legal awareness, you are going to convince. And what purpose you are reading law? You have to convince the people. Then automatically they have, yes, our rights are curtailed. Our rights are deprived by the persons. We have to go before the appropriate authorities. And they do not know. Illiteracy is there still. So you have to convince them. Just I am convincing you. I am not only convincing to you, but you should also remember that it is part and parcel of your duty to protect the interest of the people.
Definitely, sir.
Thank you.
And thank you so much, sir.
Welcome, madam.
This is a entirely new subject, and we are not matured enough to, find more questions. But sir, you covered things very nicely and very deeply.
Thank you very much. Thank you, sir. Thank you. Opportunity. I want to spend along with you, and it shall be go to each and every public at large through you and myself. I think it is very useful for the people also.
Yes, sir.
Thank you then. Shall
Yeah,
I
thank
close
you, sir.
now?
Thank you.
Thank you, everybody.
Thank you, sir.
Thank you. Yes. Yes.